welcome you to IGNOU and National Law University Delhi Public Legal Education Program. Today we will discuss about law of arrest. Law of arrest is a very important area in criminal law, and the police is the visible contact for any citizen. In fact, police symbolizes the criminal justice system. If you ask any ordinary citizen about any criminal justice system, they will first say that only the police is this. So the initial contact of the person is with the police. And after the arrest and detention plays a crucial role, and we have the two panelists. We have Mr. Sarvanan, ACP House Guard Police Station, and we also have Mr. Manoj Jain, Special Judge CBI in the Saket Courts. And whenever we discuss about the law of arrest, first the entire powers are given to the police under the CRPC. So we will begin with Mr. Sarvanan about the powers of arrest given to the police and what is his view in his everyday experience, and after that we will discuss, we will interact with Mr. Manoj Jain, how the courts are looking at in the interpretation and implementation of the law of arrest. So let's begin with Mr. Sarvanan. And there are several landmark decisions which have come, how this impact has been created. So now I will request Mr. Manoj Jain ji, Special Judge, CBI Judge in Saket Courts, to explain us what is the law of arrest and how the courts looks at some of these powers given to the police.
Thank you, Mr. Rao. And Mr. Sarvanan has already given a very vivid view from his perspective, which is rather more important. There is no denying the fact that the topic is topical. It is the most crucial and important topic for the day, and probably would remain for the coming days also. A common man would ask as to why are we really talking about the rights of an accused? After all, he must have done something wrong, something illegal, or maybe just going to commit some offense and he is being detained on the basis of apprehension. And then why are we talking about rights? Why such person deserves any right who has done something simple? So is it not proper from the angle of common man to think that his liberty should be curtailed and he should not be given any right as such? But then we have to be mindful and cognizant of the fact that we are living in a system, we are living in a country where there is a system of adversarial law. It means that the USP of adversarial system of law is that there is a presumption of innocence in favor of any such person. Unless and until such person is held guilty by a court of law, he has to be presumed innocent. And if that being so, then we have to give what such person deserves, what such person expects from the society, from the law enforcers, from the law protectors. After all, any such accused is a human being in first place. And if he is a human being, then naturally he has inherent dignity. Nobody is permitted to compromise with the dignity of a human being. If dignity is removed, a person is virtually reduced to animal. And curiously, we are living in a world where we are even talking about rights of an animal. So all the more it is important that the dignity is not compromised, it is adequately protected by the police or by the court, as the case may be. There is no question of compromising with the dignity at any point of time. As an accused, I would feel that he has some legitimate expectations from the system. Whether it is court or police, he has some legitimate expectations, and with the passage of years, with the constitutional provisions, with the judicial pronouncements, these expectations have crystallized in what we today call custody jurisprudence or the rights of accused person. Now, before I come to law of arrest or the rights, I think it would be more appropriate if I make reference to two important judgments. One judgment is coming from US. This is a landmark judgment which is also referred to in D.K. Basu case, which I would naturally advert to refer to at a subsequent point of time. This US case is known as Miranda versus Arizona. This is of 1966. An incident had taken place in Phoenix, Arizona in 1963. The case relates to a sexual assault and kidnapping. This gentleman, Arizona, was picked up from his house. All of a sudden, he was picked up and he was not told about his valuable rights, despite the fact that in American Constitution, there are so many important rights. The first 10 amendments of US Constitution are known as Bill of Rights, and there are all the possible human rights which you can find in these Bill of Rights. Despite that, he was taken to interrogation room. He was interrogated for 2 hours. When after interrogation, the interrogators came out of the room, they were having a confession. The confession made by Mr. Miranda, in which he has stated, so to say, I have understood all my legal rights. I know that what I say can be used against me, but I am knowingly and consciously waiving my all such legal rights. On the basis of the confession made by him and probably the other evidence, he was ultimately tried and convicted for and sentenced for 20 years. The matter went into appeal, and the Supreme Court of US held that the legal rights had been blatantly denied to the person. He was not made aware about his legal rights. He was not told that he could consult his lawyer, his attorney, before he was subjected to any interrogation, and this written disclaimer was outrightly rejected by the Supreme Court of US. Now, because of that particular landmark judgment, now in US, the rights are popularly known as Miranda rights or Miranda warning. These are 5 rights virtually. First right says that you have a right to remain silent. The second is whatever you say or you do can be used against you in the court of law. Third, you have a right to engage attorney. Fourth, if you don't have any attorney, the same can be provided to you. And the last, that have you been able to understand all these legal rights or not? In case the answer is an affirmative, then we would say that yes, he has been adequately informed about his legal rights. Our Indian Constitution and all the provisions contained in CRPC, including the recent amendments, are probably modeled on English law, American law. If we start tracing out the history, probably from principles of natural justice, Magna Carta, the liberties proclaimed by the King, American Constitution, Bill of Rights, and thereafter Declaration, the Universal Declaration of Human Rights. I think that's an important piece, an international covenant on civil and political rights. But despite there being so many rights recognized globally, it was still felt that in India, the custodial torture was very rampant. There was no end to custodial torture. Custodial deaths were taking place frequently all over India. Now, the case of D.K. Basu is very interesting. Actually, D.K. Basu was executive chairman of one non-political organization working in West Bengal. It was in the field of legal aid. Mr. Basu was really disturbed and shocked to know that there were so many custodial deaths taking place in West Bengal. He did a very simple thing. He collected all the clippings related to custodial death which had taken place in West Bengal and put those clippings in an envelope and sent that to the Honorable Chief Justice of India. He had made a prayer also that in view of these shocking incidents, there is urgent need of developing a custody jurisprudence. His request was entertained. It was rather converted into a PIL, public interest litigation. In the meanwhile, one more letter was received from one Mr. Johari, and he also referred to custody death which had taken place in some other area. It was also clerked with the same petition of Mr. Basu. And then, while considering that matter, the Honorable Supreme Court of India appointed a amicus curiae, roamed in all the states of the country, took reply from each of the states, and surprisingly each of the states came with the answer that everything was fine with us and there was adequate protection to and the rights were properly given to the accused person, and there was no requirement of any further direction. But the Honorable Supreme Court sensed the urgency of the matter and came up with number of guidelines. I think those guidelines are virtually written in an epic. These can be rather said to be a Bible for all of us. And if I may be permitted to say, then I would rather describe the guidelines by way of illustration. Suppose there is a person, एक शख्स है अपने घर में बैठा हुआ है और मान लेते हैं कि उसने कोई अपराध किया है, कोई ऑफेंस किया है. अब उसके घर के दरवाजे पे खटखटाहट होती है, 3-4 लोग दनादन उसके घर के अंदर आ जाते हैं. What would be the first reaction? उस आदमी की पहली प्रतिक्रिया क्या होगी? आप लोग कौन है भाई और क्यों आए हैं यहाँ पे? The first right emanates, डीके बासु का जो पहला राइट है वो वहीं से निकलता है कि जो शख्स अरेस्ट करने आ रहा है, he has to wear a name tag clearly reflecting his name and designation. The person should know that the persons who are entering his house or about to arrest him are from law enforcement agencies. There might be a case जहाँ हो सकता है वो कोई ऐसी enforcement agency हो जहाँ कोई prescribed uniform नहीं है. In that situation, it is required that they should flash their identity card. सबसे पहला कदम यही होगा कि अगर